Now let's move on to the Model Penal Code rule, which is called the Substantial Capacity Test. That rule states a mental disease or defect resulting in the defendant lacking substantial capacity to either appreciate the criminality of his conduct or to conform conduct to the requirements of the law. Once again, under the Model Penal Code, which is also known as the Substantial Capacity Test, the rule states it's a mental disease or defect resulting in the defendant's lacking substantial capacity to either appreciate the criminality of the conduct or to conform his conduct to the requirements of the law. I want you to note that the Model Penal Code, which is basically the Substantial Capacity Test, is essentially a combination of both the McNaughton test and the Irresistible Impulse Test. I'm going to go over that one now. Number 3, the Irresistible Impulse Test, the rule states that the defendant's substantially impaired mind caused a lack of ability to control the act committed. Again, a substantially impaired mind of the defendant caused a lack of the ability to control the act committed. The last one is called the Durham Rule. It's the but-for test. I highly doubt you'd get it either on an MBE question or in law school because it's the very, very, very minority. I think only one state follows it, but just so you know it, the Durham Rule basically says but for the mental illness of the defendant, he would not have committed a crime. Once again, the Durham Rule is but for the mental illness of the defendant, he would not have committed the crime. I'm going to go over those one more time just to recap. We have under insanity 4 main theories. They are the McNaughton rule, which is the right or wrong test, the one you want to follow on the MBE, unless they ask you for the Model Penal Code. If they ask you for the Model Penal Code, you're going to use the Model Penal Code Substantial Capacity Test. That was number 2. Number 3 is the Irresistible Impulse, meaning inability to control oneself. And number 4 is the Durham Rule, which is the but-for test that you would use. The next section that we're going to go over is diminished capacity. You would use diminished capacity to negate specific intent crimes. So let's go over that real quick. The rule of law says diminished capacity may be used as offense and is limited to specific intent crimes. It's where the defendant could not form the intent due to diminished capacity as a result of a mental defect or disease. Once again, diminished capacity states that it may be used as a defense and is limited to specific intent crimes. It's where the defendant could not form the intent due to a diminished capacity as a result of a mental defect or disease. The next one, under excuses, is number 3, and it's infancy, and that's when they give you a child in the fact pattern. So I want you to know that over 14 years of age, you're going to treat them as an adult. So if you see someone that's 15, discuss it, that they discuss infancy very quickly, but dismiss it saying that they are 15 or over, so we're going to treat them as an adult. If they are 7 to 14, there's a rebuttable presumption that they lack capacity to commit a crime. If they are 0 to 6 years of age, it's conclusive that they lack capacity. Once again, over 14 years of age, you're going to treat them as an adult. So meaning if they give you someone that's 14, you're going to discuss their infancy and the fact that there's a rebuttable presumption that they lack capacity. If they are 15 or above, I want you to discuss it very quickly and dismiss it and say that we're going to treat them as an adult. Because if they're using a child in the fact pattern, it's something that they want you to at least bring up. The ages of 0 to 6, it is conclusive that they lack capacity. So that is infancy. The next one, number 4, is intoxication. And we have 2 types of intoxication. We have voluntary intoxication and involuntary intoxication. So again, under excuse, number 4, intoxication, there are 2 types of intoxication. There is voluntary intoxication and involuntary intoxication. The general rule is that both may be a defense to an intent to commit a crime where it negates a mental intent element of a specific intent crime. Once again, the general rule is that both voluntary intoxication and involuntary intoxication may be used as a defense to a specific intent crime when it negates a mental intent element of a specific intent crime. So let's go over the general rule for voluntary intoxication. It can be used as a defense to negate specific intent crimes, but it's no defense to general intent crimes. Once again, voluntary intoxication can be used as a defense to negate a specific intent crime, but it is no defense to a general intent crime. Involuntary intoxication, the rule is that it can be used as a defense for specific intent crimes and general intent crimes. So basically, why do we allow that? If someone didn't voluntarily get drunk and their capacity was diminished because of it, we're going to allow them to use that as a defense. And how do they involuntarily get intoxicated? Someone could put something in their drink, for example, and they didn't know someone put some type of a drug in their drink. Can we hold them liable for their diminished capacity under involuntary intoxication? No, because they didn't get that way voluntarily. So again, just to recap, under intoxication, there are two types. There is voluntary intoxication and involuntary intoxication. Both of them, the general rule is they are valid defenses to specific intent crimes when it negates a specific intent element needed to find the specific intent for that particular crime. For voluntary intoxication, it is still a defense to specific intent crimes, but it is not a defense to general intent crimes. Involuntary intoxication is a defense to both specific intent crimes and general intent crimes. So you need to know that, all right? The next one under excuses is mistake. There are two types of mistake. Those are mistake of fact and mistake of law. Once again, number 5 under excuses is mistake. There are two types of mistake: mistake of fact and mistake of law. Mistake of fact, the definition is an honest and reasonable mistake of fact may excuse conduct which would not be illegal if the facts were as the defendant mistakenly believed them to be. I'm going to say that again. Mistake of fact, definition, an honest and reasonable mistake of fact may excuse conduct which would not be illegal if the facts were as defendant mistakenly believed them to be. A mistake of fact can be unreasonable. There must be a good faith of an honest mistake. Once again, if it's a specific intent crime, mistake of fact can be unreasonable, but it must be a good faith, honest mistake. So let me give you an example. The defendant is charged with larceny of taking a coat. He's inside of a restaurant and his coat's hanging up at the front. He walks up, he grabs his coat and he walks out. Someone comes running after him, the police come running after him, and they arrest him because he just stole somebody else's coat. Well, he accidentally picked up the wrong coat. His defense is, I mistakenly believed that it was my coat. He just happened to pick up the wrong coat. So larceny, the intent is the intent to steal the property of another. If it negates, if the facts were as he believed them to be, meaning he believed that the coat belonged to him, we're not going to find him liable for that. We're going to allow him to use it as an excuse to negate the specific intent of stealing the property of another. Again, remember, specific intent crimes, mistake of fact can be unreasonable, but it must be in good faith and an honest mistake. So the example that I'm giving you is larceny, where someone takes a coat thinking it belongs to him. The mistake of fact will be a valid defense if his own coat was actually hanging on the same rack and he just happened to pick up the wrong coat. I want you to know that general intent crimes, the mistake must be reasonable and in good faith. An example is in rape, for example. Let's say the defendant had a reasonable and good faith belief that he had consent to have sex with the victim. Mistake of fact may be a valid defense in that type of situation, okay? But again, general intent crimes, mistake of fact must be reasonable and it must be in good faith. The example that I'm giving you is a general intent crime of rape. When the defendant has a reasonable belief and a good faith belief that he had consent to have sex with the victim, he may use that as a valid defense.